Welcome back to the Black Table here on the Black Star Network. This is our weekly hour devoted to exploring ideas and subjects of special importance to people of African descent and to others fighting to build a better society. I'm your regular host, Greg Carr. Very happy to be with you, and thank you all for the growing viewership. We're really happy and excited about the Black Table and all of the programs here on the Black Star Network. Well, today we have invited our regular legal roundtable scholars back for a conversation. It's been a busy Supreme Court term, as we know. We've had several conversations stretching back into the months preceding the confirmation of Ketanji Brown Jackson, and we've talked about all of the major cases before the court this term, some of them quite extensively, i.e. the affirmative action case. But the first week of December, there were two cases that the Supreme Court heard that are potentially transformational, not only to the United States, but in many ways the history of jurisprudence in the structure of this country that we call the United States of America. Moore versus Harper, which was argued on the 7th of December, and 2 days before, 303 Creative Limited Liability Corporation versus Elinas. And back with us today to talk about both of these cases in the context of what was argued and the meaning of these cases, we've invited back, of course, our regular legal roundtable, Professor Angela Porter of the American University, Washington College of Law, and Professor Valethia Watkins of Howard University, Department of Africana Studies, and the director of the Graduate Women's Certificate Program. Welcome back. Welcome back, scholars. How y'all doing?
Hey, good morning.
It's good to see you all, albeit under some very austere circumstances. Heard a lot of alarming kind of bell ringing as it relates to these particular cases. And of course, in the oral arguments, we've heard everything evoked from Black children in Klan outfits to Scientology and all kind of other things in various and sundry examples. Why don't we start before we get into either of the cases with some of your impressions on this current Supreme Court term? Are either of you surprised by what we've seen unfold, given what we anticipated might happen with this so-called supermajority of the conservatives on the court?
I would say not surprised, because none of these cases should be viewed in isolation. We need to always connect the dots, and this is a part of a comprehensive movement, anti-democratic movement that is at the base a power struggle about how this country is going to organize itself going forward. And so at the heart of this power struggle is this attempt to concentrate power into the hands of one political party that has demonstrated since the January 6th election, if not before, that it no longer believes in democracy. And at every single angle, it is, in terms of government, it is attacking the system. And so these cases are interrelated, as when we talk about them, they're going to unfold, but they're building incrementally this kind of firewall against being accountable to the people. And so we can't get weary, because when we look in the context of this recent election and the people did what was necessary to try to hold this movement at bay, the movement has not stopped. And so they don't get weary. They continue on. So when they suffer a defeat, they just come up with a new scheme to get their political way. And so we have to be just as tenacious, if not more, because we really have a competition of visions of what this country will be. And we have every right to stand up for the vision that is for justice and fairness. And we have to push that we have to give birth to that, because clearly they're trying to kill it in the cradle.
How about that? Working real hard. In fact, I'm glad you raised that. And Professor Porter, it reminds me of the recent news that Kirsten Sinema has switched her party affiliation to where she was all along, which is, I think she's calling herself, she's a member of the Sinema Party, if I'm not mistaken. But at any rate, at least with the victory in Georgia, there should continue to be actually more momentum to get this federal bench stocked with more judges. So I wonder if you have any thoughts about what we're seeing in terms of this court and whether or not it's unfolding the way you anticipated it would unfold.
I wholeheartedly agree with Dr. Watkins' read. I mean, this is a strategic, long-range attack on ideas about democracy. It's also a carrying out of the white nationalist, white supremacist agenda. We talk about almost everywhere with you, Greg. We talk about Make America Great Again and what that means. And going back to the days before the Warren Court or the Constitutional Revolution of the 1950s and 60s. And so it is all part of that game. I think what I wish people understood was how interconnected this all is to things like cinema, to the Congress, to Senate confirmation hearings and presidential elections, because they are trying to put people in the judiciary, in the Article 3 federal judiciary, which has lifetime appointments, so that they can carry out this agenda in the courts. They want to cheat. They want to discriminate. That's a summary of these two cases we're going to talk about today. They want to cheat and they want to discriminate, and they can do that through use of the courts. One last thing I would say to pay attention to is that story that came out about Reverend Schenck and Justice Alito and his implication that Alito and or his wife leaked the opinion from Hobby Lobby, a case involving contraception and corporations and religious freedom. Mm-hmm. What's stark about that expose is just how susceptible the court is, and all courts are, to this sort of agenda and this lobbying and this, right-wing, fundamentalist Christian, anti-Black agenda, and how tied up federal judges are in that agenda. And so this is a serious thing that's unfolding, and we ought to, as Dr. Watkins said, be very attentive to it and connect the dots between these cases, because each case in isolation is going to look like, limited, but this is expansive. Absolutely.
And this is, I'm glad you raised that as well. I mean, the headline grabbing with Clarence Thompson's wife, Jenny, and the kind of sensationalist kind of things that grab the headlines are one thing. Of course, Kavanaugh going to parties and cavorting with a bunch of people whose politics are fairly disturbing to the majority of people in this country, it appears to be. And Alito, of course, with his own challenges there, inviting these folks over to his house, and then these opinions get to somehow mysteriously get leaked. All of those things are very disturbing. In the context of what we're talking about today, I wonder if either of you, in thinking about these two cases, have any pushback against the way, particularly Moore versus Harper, has been characterized. I've seen it characterized as the single most important case for United States democracy. And it threatens to undermine, perhaps even obliterate the idea of federalism, and certainly this independent state legislature theory that has been floated, which, correct me if I'm wrong, at least if it didn't make its debut, it made its most kind of virulent appearance with William Rehnquist in a case that the Supreme Court said you should not use this case as precedent. And then here it is, surfaces again, Bush versus Gore. In our next block, we're going to dig into Moore versus Harper, but I'm wondering if you all could set it up a little bit and kind of place this case that isn't Jenny Thomas and January 6th, isn't Kavanaugh at parties or Alito inviting people over and potentially leaking opinions. But, while we're looking one way, is this case as important as it has been characterized by those in the legal community?
Well, I would say that, again, none of this should be looked at in isolation. I mean, Shelby County is equally, if not more important, because people.
The Alabama voting rights case, yes.
Yeah, Shelby County versus Alabama, Shelby County, the 2013 decision that gutted the Voter Rights Act, Section 4, But also, again, when you connect the other cases where he said, okay, don't worry about section 4, you got section 2. And then the later cases that, oh, well, section 2 is weakened and gutted. And so these cases collectively are stripping people of power and concentrating power in the hands of one political group. So it all matters. This case will matter in ways that when you talk about, it's not just the case, it's the whole structure. The Electoral College is what makes this possible as a potential way to circumvent the voices of the people.
Yeah, I would add, I would say, we're talking about Moore v. Harper. This case is crazy. Okay, I just want to lead with that. This case is straight up crazy, and it is connected, as Dr. Watkins said, and we will talk about how it's connected. But what's at stake? Elections as we know them. What's at stake? No checks on the state legislature when it comes to elections. And we already done seen how the state legislatures been acting up. We already have a prelude for what they are chomping at the bit to do. And so you want to remove a check on that? You can only imagine. I mean, we were talking about the lines in Georgia. We're talking about early voting, when you can absentee vote. We're talking about when you have to show voter ID. We're talking about who and how these districts, who gets to draw these districts, how they get to draw these districts. We're talking about whether state legislatures can violate state constitutions. And with this theory, the answer is yes. So we'll come back to it, but I will say I agree with the media's portrayal of this case as being utter insanity, because it is.
Well, let's pause here for a moment. And while we're pausing, encourage folks to download the Black Star app and to look at the previous legal roundtables, because you all have laid out a roadmap for us how to think about American jurisprudence, certainly over the last several generations. And if you go back and look at that as part of the conversation we've been having ongoing, it sets us up perfectly for the conversation we're going to continue today. Back in a moment with Professors Valencia Watkins and Angela Porter here, the regular legal roundtable at the Black Table. Back in a moment.
Black Star Network is here.
Oh, no punch!
I'm real revolutionary right now.
Thank you for being the voice of Black America.
All momentum we have now, we have to keep this going.
The video looks phenomenal.
See, there's a difference between Black Star Network and Black-owned media and something like CNN.
You can't be Black-owned media and be scared.
It's time to be smart.
Bring your eyeballs home.
You dig?
Welcome back to the Black Table here at the Black Star Network. I'm Greg Carr, your regular host, with Valencia Watkins and Angela Porter. We're discussing Moore versus Harper and 303 Creative versus Alennis. What is this North Carolina case, and what is an independent state legislature theory? This is the Moore versus Harper case, of course, that was argued on the 7th of December this year. What are we talking about? What are the facts of this case?
Well, first of all, the name, let's look at the name of this so-called theory. And I say so-called because it's actually a Republican driven, the Republicans are behind it, and it's a Republican, more so of a political scheme and less of a actual legitimate theory. The name is dangerous and controversial because it's Orwellian in a sense. Let's talk about independent, the state legislature being independent from who and what? Independent from state from state courts, independent from state constitution, and taken to its logical extension or conclusion, independent from accountability to the voters if they have their way. So this so-called theory would virtually eliminate judicial review at the state level relative to these decisions. I mean, it's trying to cut out the other state actors, the courts in particular, and accountability to the state constitution, and saying that the only check will be on them is the federal law and Congress. But in reality, going back to this North Carolina case, it is a partisan gerrymandering case. It is a case where North Carolina is virtually 50-50 Democrat Republican, and the Republicans used the 2020 map to allocate in its congressional voting maps a outcome that would have led to them taking 10 seats out of 14. And the state,
like Wisconsin. Yeah. It seems like they must be coordinating. Wait, I guess that's what ALEC is for. They seem to have to coordinate. You see this in these other states. So they were going to have a super majority that didn't reflect the voters.
The voters are voting. Democrats are getting more votes, but the Republicans are getting more seats. You're seeing it in Wisconsin.
Who's going to check them? Who's going to check them in North Carolina?
At the point, the state Supreme Court checked them. And the state Supreme Court said this is in violation of the free and fair clause of the state constitution. Okay. And so therefore they had an independent body redraw the map, and lo and behold, with a fair map, the Republicans won 7 seats and the Democrats won 7 seats. Okay. So it matters. You can vote, but if they rig those voting maps, then they could dilute the vote, even negate the vote. It becomes another tool in their toolbox.
So that's the end of the story then, right? I mean, the state legislature tried a power grab based on gerrymandering. The state Supreme Court, interpreting the state constitution, said you can't do it. It's not constitutional by the state constitution. And they ruled against these folk. And that's the end of the story, right? It's a state issue.
No, they ran to the Supreme Court and filed on a shadow docket an emergency appeal. Now,
the Supreme Court of the United States had nothing to do with it. It's the state constitution.
Right.
Wow.
Right. Absolutely.
Wow.
It should have been.
I'm just going back again to basic civics. Those people who were fortunate enough to take it. State
Federalism.
Constitutions and federal constitutions. What is it called? Dual sovereignty or something? I mean, they're not supposed to interfere with each other unless what? Go ahead.
Well, this is the central issue of the case: is federalism. This idea of what y'all are grappling at is what is the relationship between the state government and the federal government? Yeah. And because there is an elections clause in the U.S. Constitution, this is what they're hooking this whole theory on. Article 1, Section 4, the elections clause, saying that the states get to draw maps, not just for their own elections, for the the U.S. legislature.
It has a lot of the time, place, and manners of holding elections for senators and representatives shall be prescribed in each case, in each state, by the legislature thereof.
Right.
So that's very simple, straightforward.
Right. But I guess what I'm saying is because that's in the federal constitution, it creates a federal question. And that's a jurisdictional thing in the courts. It means they can go to federal court to talk about this federal issue. And that's why they could go to the Supreme Court. That's why we're talking about this in federal court.
So they're in the federal courts because it's a federal issue, but in the federal constitution, it leaves it up to the states to do that. Right?
Yes, so and the states should be able to check their legislature.
Right. It's turning on the word, what does the legislature mean in the context of the election clause? And as Neil Katyal has said, in his arguments, for 233 years, the legislature was understood not in the way they are arguing before the court. It was understood that the state legislation is dependent on being consistent with the state constitution, and the state courts get to decide whether or not the state legislature has overreached or is not constitutional.
That seems pretty straightforward. I mean, it says legislature. So that doesn't mean courts, right? Legislature just means the House and the Senate of any state, right? It doesn't mean the courts.
No, that's what she's saying. And that's what Neil Katyal, as Dr. Watkins just mentioned, said. You got to love Neil Katyal. Y'all might remember him if you paid attention to the Chauvin trial, because he was pro bono special attorney in that case representing the state of Minnesota.
The killer of George Floyd, the convicted
the George Floyd murder case. Yeah. And so Neil Katyal is former Solicitor General. He's argued before the Supreme Court many, many times. I think he broke Thurgood Marshall's record as being a non-white arguer before the Supreme Court.
So what is he saying? Legislature doesn't mean legislature?
No. Neil Katyal is representing Common Cause in this case, which is saying that they shouldn't be in the state independent state legislature theory. He's saying legislature means the whole state apparatus. And I love how he called out Justice Thomas during his oral argument. He basically said, and I quote, Justice Thomas, if I may, in the 2 decades I've been arguing before you, I've wanted this precise case because it speaks to your method of interpretation, which is history. I mean, he straight calls him out.
And what Dr. Watkins, you just said, for 200 plus years, legislature doesn't mean House and Senate exclusively. It means, as you say, Professor Porter, the whole apparatus, the power that makes the laws. So when they said legislature, they did not mean just the people in the House and Senate of a state. They meant every. And so Katyal brings Clarence Thomas out on this. I mean, is this settled law? Like you say, Dr. What, 200 some years?
33 years. I mean, Katyal points to the contemporaneous documents.
Oh,
he's like, we can start with the Articles of Confederation, the first iteration of the Constitution.
I was just those oral arguments. I'm like, wait a minute, they going back to before there were any state legislatures to make this point.
The Articles of Confederation. He points to that, which was in place from 1781 to 1789. He points to the Federalist Papers in the late 1780s, where they're not even thinking about this issue, where they're suspicious of state legislatures and basically saying they need to be checked. And then he also brought in this, lastly, he brought in this instance from New York in 1792, where there was some commission that consisted of governors, executive branch, not the legislature, and judges, judicial branch, not the legislatures, in New York. State level election plans, election procedures, because they said they went against the state constitution. So he's drawing all these things from history, saying, since you love the founder so much, Clarence Thomas and friends, why don't you look at what they were actually doing? Because they were not doing this.
Okay, well then, and there it is. I mean, as recently, if memory serves correctly, it's 2015. This very Supreme Court they're sitting on affirmed that this does not mean just legislature. So, okay, so where are
2019?
Oh, 2019.
Rucho case. But look,
jump in.
But the point is also to add to what Professor has just said is that they're saying that they are not being consistent with history, the text, and precedent, their own Supreme Court precedent. And we're not talking about precedent from the 19th century per se. Yes, that, but their recent precedent. So this court is so cavalier, so disregarding of precedent. Precedent does not matter. This is judicial activism at its worst. They are truly functioning as an arm of the Republican Party. They are disregarding their own precedent. They are disregarding things they said 5 minutes ago.
Well, that's you know what? Let's pause here, and we come back. We're going to continue right in this vein, and I want to ask both of you to walk us through where this theory is coming from, as absurd as it sounds, since it seems to fly in the face of all the precedent and all the history. Where are they drawing from, and what are they arguing, and what are the implications? So we'll be back in a moment here at the Black Table with Professors Angela Porter and Valethia Watkins, our regular legal roundtable. As you can see, we are deep into discussion of Moore versus Harper, argued on the 7th of December this year. Back in a moment here at the Black Table.
Don't you think it's time to get wealthy? I'm Deborah Owens, America's Wealth Coach, and my new show on the Black Star Network focuses on the things your financial advisor or bank isn't telling you. So watch Get Wealthy on the Black Star Network.
Welcome back to the Black Table here on the Black Star Network. Remember to support the Black Star Network, download the app, tell your friends. Our community is large and growing, and we're grateful that you've tuned in again today here with our legal roundtable discussing Moore versus Harper and the 303 Creative case, but we'll get to 303 Creative a little bit later. All right, so when we paused, I wanted to ask you a question. Where are these folk getting this independent state legislature theory, which doesn't have any traction in terms of any court ruling up until now?
You alluded to it at the very start, the 2000 Supreme Court decision, Bush versus Gore, when the Supreme Court decision based on the Equal Protection Clause stopped the Florida State Supreme Court, so therefore did not defer as usual to the state court, stopped them from counting the votes, the recount. And so therefore, Justice Rehnquist, in a concurrent opinion, began to outline this independent state legislature theory. And also take note that the current court members, Roberts, the Chief Justice, Kavanaugh, and Amy Barrett, were on a part of the legal team that was involved in the battles of the Bush v. Gore decisions. So that's part of it. But also you got to look at the fact that this so-called theory, this political scheme, was at the center, was the centerpiece of let's go back to the 2020 election and the efforts in the courts and beyond to overturn the 2020 election and reinstall the former president. This was the centerpiece theory that they were using to justify those actions. 62 courts rejected that, and the majority of them, not majority, but many of them were state courts. And so this very theory would cut the state courts out of this conversation.
So I should add a note though, quick. Barrett, she was involved in the litigation related to Bush v. Gore, but not Bush v. Gore proper. She was arguing against the independent state legislature theory, which actually leads us to another point, which is this is a results-oriented thing. Okay, they're using theory to get to the results that they want. Barrett is arguing back in 2000 to try to get Bush to win, but in their specific case, she's arguing against the theory because they need the state courts to say they can count these Republican absentee ballots in her issue. So it's this narrow issue.
Critical.
Yeah, but it's all results-oriented, which goes back to your question of where does this come from? It comes from white nationalism.
But you know, Carr, I would like to add this one small point. Again, when we look at Bush v. Gore, it was so outside of the boundaries or normal interpretation of the Equal Protection Clause. And I remember hearing clearly the court say that this case should not be used as precedent. It is very specific to this fact.
That's right.
But in reality, it is being cited for precedent, not only for this recent case, but in the cases leading up to this particular litigation. So again, they're ignoring their own precedent.
So for folks, let me say for folks who may not have the legal background and may be a little off in here, say, wait, hold on. Okay, it's very clear. In the year 2000, the state of Florida sent its electors to in the process, Electoral College, they were counting the votes for those who voted for Bush or Gore, and they were ordered to stop by the Supreme Court of the United States. There's no precedent for that because it was a state court, the Florida Supreme Court, that allowed them to continue to count votes. And this was strictly within the state legislature, state Supreme Court. And so you think, okay, it's not a federal issue. And Bush versus Gore, as you say, they intervened. The United States Supreme Court intervened in a state election. And that's why they opened that case, as you say, by saying you can't use this as precedent. Why? Because it's strictly political. But when William Rehnquist, near his death, spits out this silly theory, this independent state legislature theory, because I'm sure you all both remember, while the Supreme Court had allowed, or Florida had allowed these votes to continue to be counted, the state legislature in Florida was preparing to potentially award the votes to George Bush, regardless of what the popular vote came out to be. As you say, they were just looking at a way to give Bush Florida. The way they came up with was stop counting votes, because as we know, Al Gore was closing. With every wave of counted ballots, Gore was getting closer. Ended up with 537 or whatever he lost by. But anyway, I said all that to say.
And remember, whose brother was running the state? Who was governor of Florida? Jeb Bush. Who was the Secretary of State? Catherine Harris. Who was on the Bush campaign? So
that's right.
There was no, kind of impartiality in the process. They were putting their thumb on the scale for sure. No question. And we might, so just to get where you raised Professor Porter, it's very interesting. Comey Barrett, people are saying now, well, in this current case before the court, perhaps she's a swing vote, but you just explained why she wouldn't be a swing. She came out against the independent state legislature theory, not because on legal principle, but because pragmatically and politically, it might aid the guy she was caping for. Even Roberts and Kavanaugh on the other side. This is deeply disturbing, because you got people out there thinking, well, she might not be as open to the independent state. No, it's politics. So walk us through when we see this dead theory rear its head. I'm thinking about the Wisconsin case where Kavanaugh and Gorsuch, jump into that Wisconsin legislature, the Pennsylvania case in the election of 2020, where you see Alito gesture toward. Do they have the numbers now to enshrine the independence? Go ahead, John.
Well, two things. So one, I think the majority of them are going to give credence to this theory, but they will differ on how, I think. Based on what I've heard in the oral arguments, and based on all that we've talked about, these conservative justices have different approaches. So there may be a plurality as to the breadth of this and how it exactly works. And I got a lot more there that I can talk about, but we don't have time. But I do think they're going to honor the theory, which does open up a whole can of worms. And I do want to say this before we move to the next case, which is, this impacts our people specifically as to racial gerrymandering. This case is about partisan gerrymandering.
Walk us through that.
And we talked about this in a previous show, but every state has equal protection clauses written into its state constitution. There was a moment in the oral arguments where Kagan said, hey, this theory you're talking about gets rid of checks and balances. And the petitioner's lawyer said, that's okay, because federal checks apply. You still have the Congress and you still have the VRA. The Congress, which is a product of gerrymandering, and the VRA, which, as we've talked about, is being gutted as we speak, not only by Shelby County, but is about to be gutted by Merrill versus Milligan, the Alabama case we've devoted a show to. And so
that's right.
If you get rid of those things, you don't have checks and balances. Who is going to check the states about racial gerrymandering? No one. And so that is something that is not expressly stated in this case on its face, but that is definitely a result of this case. The amici have said that in some of their amicus briefs. We talked about it without even reading. That was before this even came up to oral argument, really. And it's a predictable outcome. So this does go back to white nationalism. This does go back to the hatred and loathing for Black people, for brown people. They are going to take us back to disenfranchisement if this goes through.
Let me call a little bit of an audible today, because I think that while we might evoke 303 Creative today, I think we probably need to stay with this case a little longer, and maybe we'll do a separate one on 303 Creative, because this is so important. So help us. Worst case scenario, a state legislature could, if they uphold the theory of independent state legislature in its worst sense, they could, if let's say the citizens of Tennessee vote for someone other than the candidate that the legislature wants to win in a presidential election? Could they substitute the will of the legislature for the will of the voters of that state?
Yeah, and I'll tell you how really quick. So we're talking about the Elections Clause, Article 1, Section 4, which is about congressional elections. It's not about presidential electors. Mm-hmm. The thing is, if they give credence to this theory as to that, the same language arises about the Electoral College in the Constitution. They still point to legislature of the state. I mean, it's just like one. It would easily transfer to the electors. Absolutely. So that's what you're saying. I just want to make it clear, though, that is.
We might even insert a graphic for both of those. Article 1, Section 4 earlier that you mentioned, and then in Article 2, Section 1, it says the executive power should be vested in the president. We know that. Then in the second paragraph, each state shall appoint in a manner such as the legislature thereof may direct a number of electors equal so forth. So you're saying that in that clause too, they could say, we don't care how you voted. In Alabama, you may have voted for X. We like Y. We own the legislature. We're gonna appoint the elector.
It's statutory interpretation. If they say legislature means X in this case, then it means the same thing across the Constitution. So they don't even have to bring another case. That's just what it is. And
again, the point you all raising earlier, in the history of the United States of America, legislature has meant the power to make the laws. So if they tried that in Alabama up until now, the Alabama Supreme Court interpreting the Alabama Constitution would tell the Alabama legislature that is unconstitutional by the state court. What they're arguing is you can't check us with the Supreme Court of the state. You can't check us with the state constitution. We're going to use the federal constitution to give the literal legislature, House and Senate of any state, the power to do it where the hell it wants to do with nobody checking them. That's not overstating. Is that overstating it?
No, absolutely not. And so they tried so it's broken down in both ways, as you say, the elections and the electors. The 2020 cases dealt with the electors. That was the whole fake elector scheme. That was the center of the argument. So they've already revealed they're going to do it with the electors.
And that's what John Eastman tried to get the Arizona head of the Arizona legislature to do. Just put your own electors in. You're the Arizona legislature.
Right. And so people try to say, oh, well, you know what? They can't do that after the fact. They don't have to wait till after the fact. Once you give them this power, they can just say it beforehand that the state legislature exclusively has the power to determine the electors who will represent the state. This is a major and dangerous power grab that will make them totally, when they say independent, they mean independent of the state courts, the state constitution, and the voters. That's the most important part.
So let's pause here, Prof. And when we pick up after the break, we're going to continue this conversation. And those of you who are looking forward to us discussing 303 Creative, we're going to have a separate Black Table on this, because Professor Porter, you were being prophetic when you said it's going to seem like the time goes and we didn't get into it. So we need to stay on this one. See if that's all right with you all. Is that okay?
Yes.
Very good. Then we'll be back in a moment here at the Black Table on the Black Star Network. Back in a moment.
When you talk about blackness and what happens in Black culture, we're about covering these things that matter to us, speaking to our issues and concerns.
This is a genuine people-powered movement.
There's a lot of stuff that we're not getting. You get it, and you spread the word.
We wish to plead our own cause. Too long have others spoken for us. We cannot tell our own story if we can't pay for it. This is about covering us. Invest in Black-owned media. Your dollars matter. We don't have to keep asking them to cover our stuff. So please support us in what we do, folks. We want to hit 2,000 people, $50 this month, raise $100,000. We're behind 100,000, so we want to hit that. Y'all money makes this possible. Check some money orders. Go to P.O. Box 57196, Washington, D.C. 20037-0196. The Cash App is $RM Unfiltered. PayPal is R Martin Unfiltered. Venmo is RM Unfiltered. Zelle is Roland at RolandSMartin.com.
Welcome back to the Black Table here on the Black Star Network. I'm your host, Carr, and always reminding everyone to support the Black Star Network. Download the app, watch all of our shows. And today we are continuing with our regular legal roundtable, Angela Porter and Valethia Watkins, and we're talking about the case of Moore versus Harper, the independent state legislature case. And when we left, we were talking about the implications of this case. And listening to the oral arguments, was there anything that struck you all as particularly disturbing in terms of what might happen? What might happen should the independent state legislature theory, which would unleash potentially state legislatures around the country to do whatever they wanted when it came to federal elections with no check from the Supreme Court of their state, from the state constitution, or from the federal constitution, what are the implications of a ruling like that?
Well, you will on its face have elections, but will they matter in the sense of the amount of disenfranchisement that is going to take place, the negation of the will of the people, the unaccountability to the people? You're going to have the negating of a number of state laws. You're going to have if they want to come in and make all kind of capricious and arbitrary rules, like, hey, no voting on Saturdays, no early voting, no, mail-in voting, no, whatever they want to do. There's nothing constraining them. So we already see with the limited constraints that we have in place now, their desire to put in place a whole stream of suppression laws. It will just be on steroids if this is allowed to go forward. And you're going to have chaos because you're going to potentially have one set of rules for state election and another set of rules for federal election. And so don't go past that one quickly, but help us with. So you're saying in a state, let's say the state of Florida, you have state elections that will be governed by the state constitution and the state Supreme Court. In a federal election, that will be governed by the state legislature and nobody else. Is that what you're saying? Absolutely. And, at KBJ, Justice Jackson kept making the argument, how is it that the state legislature is viewed as separate from the state constitution, which is the document that brings it into existence? So how can you separate the two? And you can't have this without judicial review. So it would really just turn on its head all of the rhetoric about, democracy, checks and balance, free and fair election, one person, one vote. All of that will just be like in another country where you have like Russia or the Soviet Union, you have the appearance of election, but somehow Putin always get 90% of the vote. And I'm not clear that represents the will of the people.
Professor Porter, you have any thoughts about this? I'm just thinking about the fact that there will be states, and I don't want to speculate, but let's say California, New York, maybe Pennsylvania. It depends, because we saw in the 2020 election, Samuel Alito was hot for the idea of independent state legislature. He was talking about setting aside. I think this was with the mail-in ballots. And the audible that was called in Pennsylvania to extend the count for mail-in ballots. But I could see some states saying, we're going to play by our rules and allow our state constitution to take charge and and then other states, say Mississippi, Louisiana, I don't know, where that won't be the case. I don't know. The United States didn't face that during the Civil War. I mean, is there any precedent for what we might see if they allow this independent state legislature theory to become law?
No. And I think one of the interpretations of the theory, so remember how I said the conservatives sort of differ on how they all like it, but they differ on how it would work.
Yeah, please help us.
One of the interpretations that Kavanaugh, Roberts, and Coney Barrett, I think, probably seems to favor is this idea that the state courts could very narrowly in some respect, review what the legislature is doing per elections, but the federal courts check those courts. And so that actually shifts the check to the federal system, which they love because that they got their people in there. including them, the Supreme Court. So it actually could potentially inflate the role of the Supreme Court in state elections of federal.
Am I missing something? Or if that is the case, that narrow interpretation, have these three, counting Roberts, would they have finally realized the dream of Bush v. Gore, which they said at the time because they couldn't bring it off? Don't use this for precedent. 22 years later, though, we're gonna make Bush versus Gore the law of the land. We're just gonna reach down into the states, do whatever the hell we want.
Right. And that's the difference between actually the idea of precedent and just what is persuasive. This is the power of concurrences, like Rehnquist's concurrence. This is the power of dicta, which is an opinion like that says it's not precedent.
What that means, Professor Porter. But law students pay particular attention to what you're about to hear. Go ahead.
Well, concurrence means that you as the justice agree with the result, but you have differences on well, you can concur in different ways. You can concur in the result, but you have differences in your reasoning to get there. And that's what Rehnquist is doing. He's saying that we should use the independent state legislature theory to get here with this result in Bush v. Gore.
But I'm going to go for the outcome, but I'm going to slip this little theory in, which I don't have the numbers for yet. But one day.
Yes. And when you read these opinions and when you listen to these oral arguments, you got to be thinking on that level too. And I know we'll come back to this when we do 303 creative, because it really is at play here. But what the justices are doing is they're speaking to, posterity. They're broadcasting to conservative think tanks. They're broadcasting to right-wing judges and lawyers. So they're like, hey, we may not have won the battle, but we can win the war. And here's the plan. Go carry it out. That's essentially what Rehnquist is saying with that theory. And that is what they could say here with whatever they come up with. It's like, hey, we got this far in this case. Now y'all bring us another case based on the theories we're talking about in our opinions.
Which goes to what you said, Professor Watkins, at the very beginning. Inch by inch, by being disingenuous. This check is here. Now y'all got a case coming for that. You got a case coming for that. Go ahead.
Yeah, I was going to say, again, connected. So in Rucho in 2019, he says partisan gerrymandering, and by he, I'm talking about Chief Justice Roberts. He's saying partisan gerrymandering is a political question that should be dealt with at the state. It is beyond the federal bench. And now, 2 days later, a couple of years later, they're saying now that potentially that under the light version of the theory, that now it is in that narrow interpretation that it's going to be the federal court overseeing the state courts. So first of all, it's upsetting federalism because it's upending deference to state interpretation of state constitution. Secondly, they've already demonstrated an unwillingness to deal with partisan gerrymandering. So if they're left to be the wolves guarding the hen house, the hens are in trouble. And then thirdly, this whole scheme, the Brennan Center makes this point, and so does Michael Ludick, a very respected, prominent Republican, respected by the Republican, of a lot of these people. Mm-hmm. His point was, the Brennan Center basically made the argument, there's no such thing as a light version of this theory, that once you open this door, the theory is going to continue to expand and do the damage that it's going to do, light version or maximalist version. It is all not grounded in history, it's not grounded in text, and it's not grounded in precedent. So it is a radical power grab by the Republicans, and they're trying to soften the ground for 2024, what they could not accomplish in 2020, what they did not accomplish with the January 6th insurrection. Remember, they don't give up. They don't die. They multiply in the sense of new schemes to achieve the result they want to achieve. And so this, along with election denying, along with threatening election workers, along with running candidates who are election deniers, along with voter suppression, and ultimately, in the end, the backup plan is the conversation that Marjorie Taylor Greene was having, saying, hey, if I planned the insurrection, me and Steve Bannon, we would have won and we would have been armed. And then to say that was a joke is a joke, because the joke is on all of us if you listen to them, Because the bottom line, they've also laid the ground for political violence. And so in the context of this chaos, they are definitely priming their people for another violent attack. So this is, again, comprehensive on every level. This is a reaction to not just when we celebrate the demographic shift and different coalitions coming together. This is a notion that we are a people in power and we intend to stay in power or we will burn it down.
Thank you, Professor Watkins. And in fact, that's a perfect segue in some ways to the 303 creative case, which we'll talk about next week. We'll reconvene the roundtable for this. But as we walk from Moore versus Harper, the creative LLC versus Alennis, Professor Porter, it seems to me that the states' rights arguments, which used to be the white nationalists, it seems now that once they've seized the federal apparatus, it's really, as Professor Watkins said, about power. If we can use the federal government to accomplish what we used to accomplish at the state level, we'll just switch sides and say the federal government should intervene to kind of protect us as we kind of move and do what we want. At the beginning of our hour together, you made a comment. You said, they cheat and they discriminate.
Yes.
Wondering, it sounds like they're doing that more versus Harper, but would you set up 303 versus Alennis, which we'll talk about next week?
Yes. So 303 Creative is about a website developer who wants to discriminate. Moore v. Harper is about wanting to cheat in elections, and 303 is about wanting to discriminate. And on its face, it seems narrow. It seems like we're just talking about same-sex couples and whether creators like this website developer can turn them away. But what is at heart in that case is what is at the heart of it is this question of segregation. We're talking about public accommodations, protected classes, and there's no way to, as the Solicitor General for Colorado said, there's no way to cabin this to just a narrow situation. This would spill over into all of the protected classes: race, sex, religion, national origin.
You're not saying that if I have a website and I don't want to build a website for same-sex marriage, that also means that I can segregate the bus and the train station and the restaurant? Those two things don't go together.
That's the whole thing they're grappling with in the case, is you can't distinguish these things in any logical fashion. The petitioners are trying to, but there's no way to do that because it's so interwoven. This idea of messages and speech is so interrelated to identity. And I'll just leave on this note for people to kind of study up on. But Justice Sotomayor in that case references the case of Katzenbach versus McClune, Ollie's Barbecue in Alabama, which was about, segregation in a restaurant. And the argument there was essentially, hey, we can't have Black people in this restaurant because that would say that we endorse the message that we like integration. And so is that a speech issue or is that just discriminating? That's what's at the heart of 303.
All right, you all. That means you have to come back next week, Professors Angela Porter and Valethia Watkins, part 2 of our legal roundtable around these 2 December cases that have been argued. And if it scared you, it should, because I know for the last 20 years, people have been writing articles about how John Roberts was going to use the First Amendment to get at some things he couldn't get at in the 14th. So this sounds like this case is right in that wheelhouse. So y'all make sure that you come back next week and we can continue. Thank you. Thank you, sisters. Thank you, sister professors, for joining us again at the Legal Roundtable, and we're looking forward to talk about 303 Creative next week.
Thank
you.
Thanks, you all. Well, we're going to have a pause. I guess we could call it clearing the table, but since we're going to continue this conversation next week, we'll just reset the table. Back in a moment here at the Black Star Network.
Hatred on the streets, a horrific scene, a white nationalist rally that descended into deadly violence.
White people are losing their damn minds.
There's a name angry pro-Trump mob storms the U.S. Capitol. We've seen shootings.
We're about to see the rise of what I call white minority resistance. We have seen white folks in this country who simply cannot tolerate black folks voting.
I think what we're seeing is the inevitable result of violent denial.
This is part of American history. Every time that people of color have made progress, whether real or symbolic, there has been what Carol Anderson at Emory University calls white rage as a backlash.
This is the rise of the Proud Boys and the Boogaloo Boys. America, there's going to be more of this.
Here's all the Proud Boys, guys.
This country is getting increasingly racist in its behaviors and its attitudes because of the fear of white people.
The fear that they're taking our jobs, they're taking our resources, they're taking our women. This is white fear.
Welcome back to the Black Star Network. I'm your host, Greg Carr at the Black Table. Support all the shows on the Black Star Network. Subscribe to the app, download the app, and tell your friends. Thanking Professors Porter and Watkins for the latest iteration of our Legal Roundtable. We've been getting a lot of feedback from elders, from young people, from law students and professors, from folk just in every walk of life, and they're saying the same thing. This is the kind of information that helps us understand what we face in the world and how we can come together to intervene to create a better world, not only for ourselves and our children, but beyond the borders of the United States for everybody. So we'll see you next week when we continue the conversation with 303 Creative versus Atlantis with Professors Porter and Watkins at our Legal Roundtable. See you next week here at the Black Table.